Good afternoon and welcome. Thank you for sharing your valuable time with us during this challenging situation we are all facing together. My name is Keith Drayer, and on behalf of Henry Schein Practice Services and Henry Schein, it is our privilege to host you for this time-sensitive CARES Act webinar. We are honored to have Brandon Collier as our keynote speaker. Brandon is President of Collier Associates, a national financial consulting and law practice limited to representing doctors on the business aspects of their practices. The firm was started by the late Richard Collier in 1987. Brandon continues the tradition and legacy of expert advice for doctors and their practices. Collier Associates publishes the bi-monthly Collier Associates newsletter, which provides timely information regarding taxes, insurance, investments, practice transitions, and much more to thousands of doctors, and has done so for nearly 50 years. Following the presentation, Dr. Steve Marsh, a prominent clinician in Cleveland, and Natalie Westfall, Vice President of Henry Schein Financial Services, will engage in a Q&A session with Brandon. Thank you to those who submitted questions prior to the webinar. We will answer as many as time allows. If you would like to ask a question that hasn't been answered today, please send it to the email address we will share at the end of our session. After I read the disclaimer, it will be my honor to turn the webinar over to Brandon. And now for the disclaimer. The information shared during this presentation is intended to be informative in nature and is not intended to be a substitute for legal advice. Information presented and discussed was obtained from sources we believe to be reliable, but it is not guaranteed. Given the changing nature of federal, state, and local legislation and the changing nature of court decisions, we do not undertake any obligation to update or revise any statements constrained herein or correct inaccuracies, whether as a result of new information, future events, or otherwise. Listeners must make their own business decisions. Nothing contained herein should be treated as legal, business, international, regulatory, insurance, tax, or financial advice. Here you can see our guest speaker, Brandon Collier, and myself. His impressive CV is there, but I won't read it. You could find it on his website. And without further ado, I'd like to hand it over to Brandon to walk us through the materiality of the CARES Act.
Keith, thanks a lot. Since you called me last Friday to ask about putting this program together, I must say it's been a pretty hectic couple days. What we're going to talk about for the next hour or so is the CARES Act, how it applies to our practices, how it applies to us as individuals. Quick summary, this is a $2.2 trillion aid package signed into law last Friday, March 27th. The goal is to bridge the gap for the next 3 months during the government-imposed shutdown. Biggest spending bill by far in US history. And the question people are going to start asking pretty quickly is $2.2 trillion going to be enough? A key component of this, especially for us, for practitioners, is the Paycheck Protection Loan Program, PPP, also referred to as SBA Section 7A loans. I have a real thorough analysis of this up on our website, but the gist of this is as follows. Out of the $2.2 trillion, $349 billion is going to be allocated to businesses, small businesses defined as 500 or fewer employees, to keep the employees employed, paren or not. We don't have to retain our employees in order to get one of these loans. I'll get into that in more detail soon. The only requirements to qualify, pretty low scale stuff, low level stuff. Number one, you were in business February 15th. So if you shut down business a couple weeks ago, you were still most likely in business on February 15th. And you had employees for whom you paid salaries and payroll taxes. These are going to be available soon. How soon, we don't quite know, but hopefully within the next week or so. How much can we borrow under a PPP loan? Well, the amount of the loan is going to be our average monthly payroll costs over the past 12 months. The 12-month period before we apply for the loan, what are our payroll costs? What did we pay staff? Included in this is what did we pay for their health insurance premiums? What did we pay for their retirement plan contributions? We'll figure out the number divided by 12 to come up with a monthly average, multiply that by 2.5. That's the maximum amount we can borrow. And there is a cap. No matter how big that number is, it's capped at 10 million. How do high earners, say doctors, owners, associates, etc., factor into the calculation? Well, it's not that they're excluded from the computation. It's just that we're including the first $100,000 of compensation. You make $300,000 a year. For these purposes, you're treated as making $100,000 a year. On average, $8,333 per month. All right, next slide, please. If the money is then spent on staff salaries, group health insurance premiums, retirement plan contributions, plus your office rent, plus interest on pre-existing business debts, plus utilities, whatever we spend on these things during the 8-week period following the time we get the loan, that portion of our loan proceeds is going to be forgiven. That's going to be essentially a gift from Uncle Sam. That's what is so beautiful about this PPP loan. It's brand new. They haven't had this before, but because of the coronavirus, $349 billion, I think the government is prepared just to essentially give that all away. If you borrow, say, 150,000 bucks with a PPP loan and you use 130,000, for example, to pay these things, these forgivable type things, but you have 20 that you don't spend on this, then the remaining 20 does have to be paid back over time, but the payback is going to be pretty easy. Long maturities up to 10 years, interest at a low interest rate up to 4%, no prepayment penalties. In addition to that, interest and principal are deferred for 6 months to 12 months. However, interest is going to start accruing from the date the loan is made. The feds are looking to get this money into circulation ASAP. The underwriting standards are essentially nothing. You don't have to show that you need the money. There's not going to be any loan origination fees. These loans are going to be non-recourse, meaning you don't have to give a personal guarantee. It's, you're not putting any collateral up for it. It's easy to pass. I don't want to say it's easy to pass a law, but passing law is one thing. Implementing this is going to be something else. SBA and the participating banks, the banks are going to be issuing these loans. They're now scrambling to get this program set up. At some point soon, hopefully within a couple of days, they're going to publish guidance on how to go about applying for this, what kind of documentation you're going to need and so forth. When that gets published, it'll show up on SBA's website. We're going to have it on our website. But expect a document light application. Another thing, just put this in the back of your mind. If you have other debts out there, other business debts, maybe you bought a practice, maybe you bought some equipment with borrowed money, your loan agreement may not allow you to take out extra debt. Double check this. If you think this is a problem, call your lender and get a waiver. I doubt this should be a problem though. All dental practices should apply for this. Everybody should get this, including sole proprietors and independent contractors. You're eligible as well. Why? Because it's free money. The question is going to be the timing of this. Should we apply early in the process? It's going to open up hopefully in a few days. Or should we apply closer to the end? June 30 is the end. These loans are not going to be issued past June 30. More on this to come. Another big aspect of the CARES Act is what I'm calling unemployment on steroids. The states are ramping up to absorb employees who got laid off, who got furloughed, even those who are still employed on their company payrolls, but have taken pay cuts, so that have had their schedules cut back. This is going to be state by state. In general, the states are not going to require any waiting period the way they used to. And you can collect unemployment benefits while remaining partially employed. How much is unemployment going to cover? Well, usually figure about 40 to 45% of normal salary. Jury is still out on what this is going to do to future unemployment insurance premiums that we pay. However, it's likely not going to be so much that that it still won't pay for us to take advantage of unemployment while our office is shut down. The feds, the states are talking about ways to mitigate the pain on big spikes in future premiums. Now, the CARES Act is doing a few things in conjunction with state unemployment programs. Number one, anybody who qualifies for state unemployment is now also qualifying for a federal $600 a week kicker. Whatever you're getting under your unemployment program, it's going to be another $600. The $600 is available to part-time workers if the state covers part-timers. If they don't, if it doesn't, then there's probably not going to be a $600 weekly check to go along with it. If this is going to be an issue, say you have 10 employees, 7 of which are fully furloughed or laid off temporarily. They will, I think, unquestionably go on unemployment. But you have a couple, 2 or 3, that you're going to keep on a part-time basis, say, to handle emergency cases. Well, their schedule is getting cut back, their compensation is getting cut back. Perhaps they are going to be eligible, based on these cutbacks, for unemployment too. Hopefully, yes. If they're not, then consider cutting back their schedule, cutting back their salary below the point at which they do qualify for state unemployment. Because if you can get them on unemployment, then they also get the $600 a week payment. These unemployment benefits typically last 26 weeks. Under the CARES Act, the feds are going to pay to keep it open up to 39 weeks, but not past December 31st. The $600 weekly payments last up to 4 months through July 31st. Talked about PPP loans. Let's talk a little bit about SBA economic injury disaster loans, EIDL, or Section 7B2 loans, 7B2 from the SBA Act. These are authorized by a different section of SBA. These have been around for a while. You can borrow, a small company can borrow up to $2 million under Section 7B2. Now, if the loan is up to $200,000, so it's a small version, then there are going to be relaxed collateral requirements, no personal guarantee. Also, if it's up to $200,000, the SBA is going to waive its requirements that the applicant was in business for at least 1 year, and it's going to waive the requirement that the applicant was unable to obtain credit elsewhere. Because of coronavirus, the SBA is relaxing its standards to get this money into circulation quick. You have to apply for this using the SBA application forms. The standard form is SBA Form 5. If you're a corporation, if you're a partnership, an LLC, that's what you use. If you're a sole proprietor, Schedule C taxpayer, single member LLC, you use Form 5C. Good news is SBA is going to have real light underwriting and may limit this only to a credit check, possibly not even asking you to supply tax returns and financial statements. One great feature of these EIDL loans is when you apply for it, you can ask for an advance up to $10,000. If you request it, it should get paid to you within 3 days, even though the EIDL application is still in process. This advance is not required to be repaid. This is essentially a gift. However, you can't double dip. You can't get both a $10,000 free idle advance and full PPP forgiveness. If you get the $10,000 with the idle application, and then you apply for a PPP loan, which you should because it's better than the idle, it's forgivable, your forgiven PPP amount will be reduced by 10,000, negating the advantage of the free $10,000. So in the example I mentioned before, let's say you borrow 150,000, 130 of which is spent on the proper things, wages, rent, utility bills, et cetera, et cetera, et cetera. 130 is forgivable. If you got a $10,000 advance, 120 is forgivable now, not the full 130. All right, next slide, please. A benefit of the 10,000 is that you may get your money faster since these applications are already up and running than the PPP program. Those aren't yet up and running, though hopefully it's going to be up soon. Now, one interesting aspect of SBA loans. Historically, a borrower could not have two SBA loans associated with the same taxpayer ID number. So the idle loan and the PPP loan are two separate SBA loans. Unless they change this rule, if you already have an idle, you cannot also have a PPP operating side by side out into the future. What's going to end up happening is the idle that you had will get refinanced into the PPP. When you qualify for the PPP and your 2.5 times of your average annual payroll costs, let's say that's X, say $150,000. If you had a $200,000 idle loan outstanding, your PPP loan is going to be 150 plus the 200. So the idle loan goes away and gets refinanced into a bigger PPP loan. So you still only have at any given point a single SBA loan out there. If you don't already have the idle, you might decide not to get it since PPP applications are going to be starting soon. However, the PPP loan is limited to just 2.5 times average monthly payroll costs. That may be too modest of an amount. If you think you need to borrow more money to tide you over, then apply for the idle first. Again, loans can be up to 2 million. You can get them up to 200,000 pretty quickly and easily, and then refinance that into the future PPP. You can't do that the other way around. You can't take the PPP first and refinance that into the idle. If you think you're going to get both, you got to get the idle first. Get the application in, get that money funded, get the cash in your account, and then do the PPP application, and then wrap the idle into it at that point. All right, next slide, please. So the $1 million question, what to do? How should we be thinking through this? If it were me, to some extent it is, number one, how much money, how much borrowing am I going to need or want to tide me over? If I figure my office or my practice is going to be closed for a few months, how much do I figure I'm going to need to get through? Some of my expenses are going to drop away. My supply costs are going to drop way down. Some of my expenses are going to remain. My office rent, for example. I'm going to plot out how much I'm going to feel comfortable needing to get me through the next few months. Number two, estimate how much I can get from the PPP loan. To do this, I got to go back and calculate what my average payroll costs were over the course of the past year. Now that includes more than just the wages I paid staff. That's a big part of it, but I'm going to include $100,000 for myself. I'm going to, as an owner. If I have associates that earn more than 100, I can include up to 100 for them. I can include in that again premiums for group health insurance. I can include in that retirement plan contributions that were made over the course of the past year. If, for argument's sake, in a typical practice, payroll is 30% of revenue. With the additions that go into this calculation, we might be looking at 40, 45, 50% of revenue is the historic prior 12-year payroll costs. I divide that by 12 and multiply it by 2.5 times. That's the amount of the PPP loan I'm going to get. If that's not going to be enough to make me comfortable, then I'm going to apply for the EIDL. I'm going to do that first, and I'm going to do it soon. And once that funds, I'll then apply for the PPP and refinance the EIDL into it. All right, next slide, please. Everyone should apply for the PPP loan because to the extent the money is spent on the proper things, it's free. Now the question is when. The issue here is timing. The loan program is going to be open in a few days, hopefully, and it's going to last through June 30. $349 billion is allocated to this. While that sounds like a lot, the interest in this is already beyond intense. And with the maximum loan amount of 10 million, seems to me pretty likely that 349 billion is going to all be spent before June 30th. If it runs out, Congress is going to have to reauthorize more funding. Will it do so? I think that's probably quite likely. Even before the ink is dry on the CARES Act, Congress is already talking about a phase 4. All right, unemployment, PPP loan, or both. I think for most practices, the best approach is going to be in 2 parts. Part A, take advantage of the beefed up unemployment that the states and the feds are offering. Do this while your office is shut down or largely shut down. Now, this is going to be traumatic. Nobody in a million years ever thought they would need to have a discussion with their employees about laying them off and sending them to unemployment. Who would have ever expected this? Having said that, this is the reality, I'm sorry to say. I think this can be couched in ways that are not so painful. For example, look, we're going to get out of this at some point. We're going to hire everybody back. This is temporary. The good news is the government is stepping in to fill the breach. The better news is if you qualify for unemployment, you're going to get an extra $600. That is going to come very close, or in some, that'll come very close to covering all your pay. In some cases, it will cover your pay. And in some other cases, you may even get a raise. Nobody wants to do this, but I'm sorry to say this is the reality. So the staff, those that are leaving, that are going to be gone, not permanently, but whose hours are being reduced to 0, can go on unemployment, I think without much of an issue. Those who are being cut back, you may have to, you're going to have to figure out or find out what your state's requirements are, how little you have to be working, how little you have to be earning to qualify. So use unemployment, take advantage of this while the office is shut down. Then as you're about to ramp back up, we get past April 30th, or whenever they loosen up the reins on the economy, you're starting to think about reopening the office. At that point, you're reaching out to your employees saying, the time is soon, we're going to be opening up the practice, we're going to be getting back to business. Around then, apply for the PPP loan. Just don't miss the June 30 deadline. Now that's a deadline for funding, not applying. You got to apply before June 30 because the money has to fund by June 30. If you get your money from the PPP loan by June 30, you're going to get the benefit of loan forgiveness for the 8 weeks following. So to the extent you're using these loan proceeds to pay the payroll for the employees you've brought back on, to pay your office rent, to pay utility bills, it is going to be forgiven. If you bring back everybody by June 30th, you get all the forgiveness. If you bring back some, but not all of your staff by June 30, the forgiveness is prorated. If you bring back most, you're going to get most of the forgiveness. If you bring back everybody, again, you get full forgiveness. And I'll say it again, if you think you're going to need to borrow more than what the PPP loan is going to pay, get the EIDL soon. Get the EIDL soon. You got some time. If staff is going on unemployment for a few weeks or a month or so, look into the EIDL at this point. All right, next slide, please. The alternate approach, if you're paying your staff and you don't feel like you have it in you to put them on unemployment, you are just too nice of a person. Maybe that's what it comes down to. Then you keep them on the payroll. You keep them employed throughout the shutdown. Is it sensible? Well, logic would say, this is business. Everybody has to sacrifice while the office is closed. The office is closed. By definition, we don't have money coming in to pay salaries. The good news is the government is stepping in here to take care of you. And with the $600 per week bonus, you'll be doing fine. Please go on unemployment. But sometimes emotion trumps logic and you can't get yourself to do it. If you're keeping your staff on the payroll, not sending anyone to unemployment, then you may as well get your PPA loan now. The benefit of taking it early is you're assured that the $349 billion is not going to be gone. Interesting side note, if you like the idea from the prior slide of, say, for the next month, having the staff go on unemployment, and then, or 6 weeks, but then when you're ready to ramp back up, apply for PPP. Can you apply now, get your application in, get in line, but defer taking the money until later? I think the answer to that's going to be no. The banks, this is going to be churn and burn. The banks are issuing these loans as soon as they can be processed. They're not going to be willing to process the loan, but defer the payout of it. I don't think that's going to happen. And I'll just say one more time, if you think you're going to need to borrow more than what the PPP loan is going to pay, and in this scenario, again, you're keeping your staff employed, taking the PPP soon. If you think you need more than the PPP loan, apply for the EIDL ASAP, like today, as soon as this webinar is over. Get the money from that loan. Once you do, then get the PPP and refinance the EIDL into it. All right, next slide, please. All right, so that was a discussion on what I think most people are here for. And hopefully that preempted and answered a lot of the questions. The next part is going to be on other aspects of the CARES Act, both business and personal issues. Payroll tax credit for employers who retain employees. If you keep your staff employed, then the 6.2% employer share of the Social Security payroll tax between now and the end of the year is going to be waived. You're going to get a credit up to $5,000 per employee. This is looked at on a quarterly basis, but figure no more than $5,000 per employee. Interesting concept, but I think it's not going to be widely applicable because it's not available to anybody who's taking out a PPP loan. If you don't, for some reason, don't take out the PPP loan, you're going to get a credit on Social Security taxes. All right, next slide, please. The employer 6.2% of the Social Security tax that we do pay, say we don't get a credit, but we are having to pay it, that's deferred and not owed between now and the end of the year. Another way we can keep some extra money in our bank account. On wages earned between March 27 and December 31st, we don't have to pay the 6.2% this year. We do have to pay it, but it's going to be split. 50% is going to be due by the end of 2021. The remaining 50% is going to be due by the end of 2022. Now, that's all well and good, but don't assume this happens automatically. Talk to your payroll processor, talk to your CPA. Make sure that whatever logistics have to be done for this, they're set up so that the 6.2% is, you get the benefit of this 2-year deferral. Net operating losses. Trump Tax Reform Act of 2017 added a rule that if you have a net operating loss, say from a prior year that you've been carrying over, and now you have a year where you make a profit, you want to be able to offset the profit with the prior year's loss. Under the 2017 Tax Reform Act, there were some limits on how much of that NOL you can use. You can't take your profit all the way down to zero. The CARES Act removes that limit and allows you to do this for 2020, 2018, and 2019. If this is an issue, perhaps you can go back, file an amended return for those back years to get a refund. Say another way the government's helping taxpayers preserve cash flow by reducing current tax payments. Defined benefit plans, cash balance plans. The funding rules are eased for 2019, which is all well and good, but interestingly, they're not eased for 2020. And that's going to be the bigger issue. So for anybody listening in who operates a cash balance plan, the kind that allows much larger annual contributions than what can go into a profit sharing plan. Unlike those flexible profit sharing plans where contributions are discretionary, you don't have to fund them if you don't want to. Contributions to a cash balance plan are required to be made. Now, when the stock market drops like it has, the required cash balance contributions go up big to prevent the plan from being underfunded. So with a cash balance plan, we're promising retirement pensions to our employees, and an actuary every year is projecting how much we should be putting in to stay on track to fund these pensions. If the plan assets drop precipitously, then the plan has quickly become underfunded, and in order to get back on track, that's going to require potentially massive required contributions. And in a year like this, that's going to be awfully hard to do because profits are going to be so hurt. So we have a problem here. The CARES Act, I suppose what was nice was the deadline for making 2019's mandatory contribution was extended from September 15th to January 1st. Interestingly, that's a national holiday. Banks aren't going to be open then, figure December 31st of 2020. But what it didn't do was offer relief for the problem people are going to have this year, which is underfunded plans. They may address this later on, but for those of you operating a cash balance plan, what you got to do at this point is talk to your third-party administrator about freezing plan accruals for your staff in 2020 and beyond. You don't want to have to make a standard contribution and be required to make up a big chunk of the loss. Staunch the bleeding. If you freeze the plan, if you freeze accruals before employees work 1,000 hours, then you're in good shape. You're not going to have to make a normal 2020 contribution. You're buying yourself time to make up some losses. All right, next slide, please. CARES Act offers now this individual recovery rebate. This is another name for the $1,200 per person government check that most taxpayers are going to start receiving within the next, say, 3 weeks. If you have a child, a dependent child, age 16 or under, there's going to be an additional check of $500. This is going to phase out for higher earners. If a single person has adjusted gross income of under $75,000 or $75,000 or less, they're going to get the full $1,200. But as their income goes up from $75,000 to $99,000, that $1,200 payment phases out to zero. For a single person making more than $99,000, they're not going to get anything. Married couples, these numbers are doubled. They get $2,400, but the phase out range is $150 to $198. This AGI is going to be determined for individuals and married couples based on the 2019 tax return. If that's not been filed, then by reference to your 2018 tax return. All right, next slide, please. If your income was too high last year, let's say your income was too high in 2019, too high in 2018, but in 2020, with what's going on now, your income is going to fall below the range. You will be able to claim $1,200 to $2,400 credit when you file your 2020 tax return, though that won't be until sometime next year. If you qualify for this rebate, are you going to have to pay tax on it? The answer is no. This is treated as the return of taxes that you overpaid. Your tax bill was X, you overpaid it by $1,200 or $2,400, you simply get a return of the money. Social Security recipients are going to get these checks too, so long as their AGI is under these income thresholds. Distributions from IRAs and qualified plans. So lots of workers, lots of employees across the country may not have a lot of money in their checking account, but they do have money invested retirement plan benefits. So if that's where the money is, that's where they may be looking. Plans can allow what are called hardship distributions. And there's a new hardship distribution criteria for COVID-19. If the individual or their immediate family has the disease, or they've suffered adverse financial consequences to the virus, due to the virus, pretty much anybody is going to fall under that. If you want, you're the trustee, Doc. If you want to open up the plans to hardship distributions, you can permit this. Now it's up to $100,000. They have to have enough vested in the plan to be able to take this out, but they can. Now, it won't incur the 10% early withdrawal penalty. If you're under age 59 and a half and you pull money out of a retirement plan or IRA, not only is it subject to taxable income, but since you're underage, it's also subject to a 10% early withdrawal penalty. That 10% penalty under the CARES Act is gone. It's still subject to income tax though, but the CARES Act says we're not going to tax it all in the year it's pulled out, say 2020. You pay 1/3 of the tax owed in 2020, another third for 2021, another third, the final third in 2022. And to avoid the tax, you're allowed to recontribute that money back into the retirement plan or the IRA. Interesting concept. I don't know a lot of practices that are going to be doing this though. Next slide. Plan loans. Another way to get needed money out of a retirement plan. The old rule was plan loans were capped at $50,000, but under the CARES Act, they're changing this to $100,000. Do you, the owner, want to be taking a hardship distribution? Do you, as the owner, want to be taking a plan loan? Probably not. Go for the PPP, go for the EIDL. hardship distributions, plan loans, these things add a lot of complexity. They're real easy to mess up. And if you mess up, let's say, a retirement plan loan and don't pay it back on time, that becomes a taxable distribution. And there may be a 10% penalty. There is going to be one if the person taking out the loan is under age 59 and a half. This is last resort type stuff. It's doable if you want to allow it, but we tend to say it's something probably to pass on. Next slide. RMDs, required minimum distributions. We were hoping for this. If you're having to take a required minimum distribution because you are of age, 70 and a half, they changed it recently to 72 for anybody who would turn 70 and a half starting in 2020. Your new age is 72 for your first RMD. If you're subject to this, the good news is you don't have to do this in 2020. You don't have to take an IRA minimum distribution if you still have a qualified plan in year of age. You don't have to take an RMD out of that either. The problem would have been these RMDs are calculated as of the beginning of the year before the stock market crash. So you would have had to taken out a large taxable distribution when the value of that has since dropped 20–30%. They did this back in 2009 in the Great Recession. I'm glad to see they're reprising it in 2020. If you've already taken a 2020 RMD, hopefully you didn't, but in case you did, the IRS, I wouldn't be surprised if sometime over the next couple of months, the IRS comes out and says, we're going to give you, we're going to allow you to put that money back into the plan and get a do-over. We're not going to tax you on this, just put it back in and you'll get the same benefit. You shouldn't be hurt because you took the RMD before this rule change came out. Next slide, please. Charitable deductions made more appealing. Maybe a minor point, but I'm throwing this in here because it is part of the law. Charities are going to get crushed this year, absolutely crushed, because everybody is earning less, everybody's net worth is less, everybody is going to be giving less to charity. In order to make it easier, the CARES Act is offering some tax benefits. If you claim the standard deduction, if you're single, it's $12,400. If you're married, it's $24,800. If you're claiming the standard deduction, charitable gifts tend not to give you any benefit because you get a bigger deduction simply taking the standard deduction. So if that's your case, you can get what's called an above the line deduction for charitable gift up to $300 or $600 for a married couple and get credit for that tax deduction. If you itemize your deductions, the old rule limiting deductible gifts to 50% of adjusted gross income is suspended for 2020. You can take your AGI down to 0 if you so chose. All right, business loans. I'll talk about student debt, government debt in a minute. Business loans, I'm talking commercial loans. Banks are being lenient. Many are being proactive. Believe it or not, they don't want to see you default. They'd much rather work out a solution, change the terms of your loan to make it doable for you, rather than declaring a default, coming in, exercising their lien on your practice assets, and taking them from you and trying to sell them for peanuts. That's a last resort. They don't want to do that. Talk to your lender, see what they're offering. Many banks, from what I understand, are already saying no payments for 60 days, no payments for 90 days. Talk to them, get something in writing from them that your loan with them is suspended for some period of time. In some cases, it's automatic, but call the bank just to be sure. All right, next slide. Student loans, this is a big deal. Student loans aren't forgiven, as some were hoping, but under the CARES Act, they're suspended, principal and interest, both suspended for 6 months through June 30 of 2020. So what kind of loans are we talking about? These are most federal student loans, not the private ones, but the ones that are held by the Department of Education. You either know what you have or you can find out what you have pretty easily by logging in to your student loan account. If you're eligible for this, you don't have to do anything, it's automatic. Just stop paying for the next 6 months. Interest isn't accruing, it's just been put in a deep freeze. These loans, as I say, they're held by the Department of Education, federal direct Stafford loans, federal direct Parent Plus loans, federal direct Grad Plus loans, DOE, not all Perkins loans, but DOE held Perkins loans, and then federal direct consolidation loans. The ones that are excluded from the 6-month suspension are commercial bank loans and commercially held federal family education loans and school held Perkins loans. Now, they don't get the automatic 6-month suspension, but they may be eligible for other relief. Look into this, see if you can get an economic hardship deferment or an unemployment deferment to put these loans on pause. If you have a private student loan, contact the lender and request relief. Unfortunately, private loans can't be converted into eligible government loans. Another bit of good news, federal collection efforts on defaulted loans is paused through the end of September as well. Exclusion for an employer student loan repayment. Now, this is probably going to apply to very few, maybe nobody on this call. But if you're a young doctor and you work in a practice where the employer has adopted something called a Section 127 tuition reimbursement plan. What this means is the employer has offered this plan to the employees, which provides up to $5,250 per year of employer paid for or reimbursed tuition, fees, and books for employees. Employees, say, working part-time in school part-time. The 127 plan is tax deductible to the employer, tax-free to the employee/student. One reason these are barely offered is because it's not a fringe benefit that the employer sees a lot of value in. Staff tends not to be in school. The CARES Act, if this exists, however, in your practice, the CARES Act amends these plans to include in the 5250 an employer's repayment of student debt. As I say, these plans aren't very common. They can't discriminate in favor of highly paid employees. Sometimes they're set up where it's the doctor parent owns the practice and the child is an associate in the practice. And if the child is the only person who has education costs, then maybe you open it up to everybody in the staff, knowing that just one person is actually going to use it, the child. But as I say, these tend not to be adopted too often. All right, well, that is it's a run through. I think I'll turn it over to our moderators.
Great. So Brandon, thank you very much. You really took a lot of complex situations and really broke them down nicely. It's really appreciated. And it really goes to show that people need to have good advisors in their corner. So I'd like to turn it over to Dr. Steve Marsh from Cleveland, a practice owner, and also to Natalie Westfall, Vice President, Henry Schein Financial Services, who has really facilitated billions of dental practice loans releases in her tenure. Steve, can you take us with the first question, please?
Sure. And I just want to mention, so Brandon and I are both located in Cleveland, Ohio. I want you to know that we are practicing social distancing, even though we are both here. We're about 1.5 miles. We all pretty much live on the same side of town. I do, like you just said, Keith, I want to thank him. And the questions I'll ask that have been sort of culled from the ones we've gotten have to do with the practice, with the practitioner. And that's why I'm glad Brandon was able to to speak the way he did. He preempted a lot of the questions that were sent in, and we've pretty much summarized some of the questions that people had asked. So Brandon, my first thought is this. Having heard this discussion, it seems that the bottom line for most practitioners, almost all of us, is that it would be prudent to take the EIDL loan and the PPA loan, regardless of our situation, even if we have a lot of money in our corporation, which would be a lovely position to be in. And if in fact that's so, can you direct the listeners to where they would go? You said the banks would take care of it. How does one apply for both the EIDL and the PPP loan?
All right, Steve. Well, I would qualify that a bit. I wouldn't, oh, well, I would take the PPP under every scenario. If money isn't an issue, get the PPP loan anyway, because to the extent that's forgiven, that's free money. The interest rate is very low. It's not going to be a major cost. The forgiven amount is going to be huge. I don't think everybody should get an EIDL loan. If the PPP is gonna give you enough based on what you think you're gonna need, then I would forego the EIDL. If the PPP is not gonna give me enough, then I would get both, apply for both. But the key point here is get the EIDL first. You have to get the EIDL first. You can't get the PPP first. Now, how do you go about applying? The SBA, you can apply for the EIDL loan right now by going to the SBA.gov and pulling up EID. I don't have the link right at the moment, but it's all on SBA.gov, the application. You can get that filed and hopefully within a couple of weeks have the funds. The PPP is that's going to be, you're going to apply directly through a bank. The EIDL is applying to the SBA directly, but the PPPs are going to be offloaded onto the banking partners who issue SBA loans. But as of yet, we don't quite know how that process is going to work.
Thank you.
Great,
And also,
thanks. Natalie, can you take the next one?
Sure, of course. Well, following up to that thought, one of the questions that we got is, if I apply for both the EIDL and the PPP and receive both of them, how do you recommend that I use the money? I understand that I must document how the money is spent in order to receive forgiveness.
All right, so in the case of somebody applying for both, remember, you can't have both of these operating side by side at the same time, but you can refinance the EIDL into the PPP. Get the EIDL first. After that funds, get the PPP, refinance the EIDL into it as part of your application. You're gonna have one loan ultimately, and that's gonna be in your business bank account, and you will spend it on whatever you need to spend it on. Much of that is gonna be things like rent and utilities and paying down other business debts, payroll costs for employees. Those are the things that are forgivable. And that's going to be over the 8-week period from the time that you get that the PPP funds. And that's going to take a little bit of work and a little time and effort to keep track of this stuff, because what's going to be required is a resubmission or a reapplication of, frankly, I don't know yet exactly how this is going to look, but a presentation of what you spent the money on, and to the extent it's qualifying things, that's going to be forgiven. To the extent it isn't qualifying things, that won't be forgiven, but the payment terms are going to be quite favorable.
Great, thank you.
so Brandon, here's the next question. Again, from someone who's practiced for 40 years and hopes to go for a lot longer. and this was sent in. My practice is shut down for emergencies. Am I obligated to pay my rent and utilities? And it's interesting, just today I got my rent notice for next month. So the question that this person asked, do I pay my rent, utilities, or are there options, and or do I go to, for example, the building owner? What are your suggestions?
Yeah. All right. Well, the question probably is, my office is shut down except for emergencies. Am I obligated to keep paying rent? Am I obligated to keep paying utilities? Well, the government hasn't fully taken over every aspect of our economy, and there were still certain things governed by private contracts, including a lease, including utility payments. So whether you owe money on or not on your rent, it really depends on what your lease says. You probably, since most leases are prepared by the landlord and signed pretty much right after that without a whole lot of review and back and forth and negotiating, you probably don't have an out for something like this, and rent is continuing to be due. Now, that doesn't mean your landlord doesn't have a heart. There's a terrific rule of life, which is, everybody knows it. It's if you don't ask, you don't get. If you don't ask for a rent abatement, you're not going to get one. So ask for it. If you get it, terrific. If you say, look, my office is shut down, I have no revenue coming in, I can't pay you, will you forgive the next couple of months of rent? You might get lucky and the landlord might say yes. What's more likely to happen, though, is instead of an abatement, you get a deferment or a deferral where you don't have to pay these 2 months, but whatever that is spread out and paid over the remainder of the lease once you're back up and running. Utility bills, same thing, it's worth calling and asking. If you don't, you don't get if you don't ask. Just because you ask, I should say, doesn't mean you get, but certainly ask.
All right, that's wonderful. The follow-up was, are there rules governing when somebody's on unemployment and you needed one of those team members to come in to help take care of an emergency? Does that disqualify them from unemployment?
Well, I hate to punt on this, but it's going to depend on what the state rules are for unemployment. If somebody is working essentially 0 hours a week, they're going to, I'm assuming that all the states are going to accept that person for unemployment benefits, no question. And if they have to come in for an hour for an emergency, the fact that they went from 0 hours to 1 hour is not going to change anything. But if somebody is right on the edge where they may lose unemployment if they work a little bit extra, then that is an issue, I think. So I guess I'll leave it at that.
Thank you.
And just adding on to that again, regarding employees, does the SBA loan continue to pay for employees even when they start back to work, but the dental office is not yet bringing in enough revenue to pay them?
Right. All right. Well, I think the better approach, which most people are going to take, is to not get the PPP loan until the practice is back up and running and the employees have been rehired, and use unemployment in the interim. That's the most strategic play here. But some people are not going to go the strategic route. They don't want their staff going on unemployment. It's anathema to them. So they're going to keep staff employed. The situation there, the recommendation there, I think, is get the PPP loan sooner, and to the extent that the staff is paid for 8 weeks following getting the PPP loan, those wages, those health insurance premiums, the rent, the office rent, utility bills is going to be forgiven. So even though the office is shut, that's irrelevant for this. You can get the loan and keep your employees on payroll. The office is closed, no patients aren't coming in, but you still get the deferment. Sorry, you still get the forgiveness on the PPP loan for the 8 weeks following the date you take the loan. Hopefully that answered the question.
Yeah, thank
It
you.
did. Thank you.
So a question we
Great.
got in a number of
Yeah,
different ways.
we'll make this the last question, please. Go ahead, Steve.
Sure. So one of the questions, because we have so many single owners who are on this call, both they may have had a corporation, they may be an LLC, they may be an S Corp, a C Corp. Should the owner, because the owner is also not taking any salary with no dollars coming in except maybe accrued people who owed them money, is there a way, and should that owner take unemployment as well along with their employees, seeing as no money is coming in?
Right. Well, Steve, I think on this, the same rule, if you don't ask, you don't get, would apply. And the owner with little or no practice revenue coming in, who himself or herself is taking a massive pay cut, it doesn't hurt to apply for unemployment and see what you get. Your schedule probably has fallen below the threshold to qualify. The question is going to be, have your wages fallen below the threshold to qualify? If you're a Schedule C, I think what they'd be looking at is your Schedule C net income. If you're a C Corp or an S Corp, they're looking at W-2 most likely, plus profit allocations. So the short answer is I don't know how that's going to shake out, but again, I don't think it hurts for the practice owner to apply and see what he or she gets. If the good news is if they can get on, then they get the extra $600 a week.
Thank you.
Thank you, Natalie. Thank you, Dr. Marsh. So there are obviously some tough conversations people are going to have with their teams. And hopefully some of the advice you heard today is going to help you with those conversations. You can see the contact information for the various speakers. We thank you for making time today, and we're all going to be rolling up our sleeves and hopefully overcoming this terrible situation. And it's good to know that there are trusted advisors that have their interests and want to help. So thank you, everybody, and have a great afternoon.